Approving traditional courts bill has been made public in Pretoria now. Justice and Correctional Services Deputy Minister Jeffery says the revised bill aims to promote and protect women who are members of traditional courts. Jeffery says the bill requires that the Minister and the Commission for Gender Equality put measures in place to support gender equality in courts and to report annually to Parliament. So to tell us more, we're very happy to have in studio with us the Minister of Justice, Michael Masutha. Minister, thank you. Thanks for being our guest here on the programme.
Well, thanks for inviting me and good morning to all the viewers.
All right, so just explain to us a little bit more. I'm sure maybe some people are not too aware of what the traditional courts bill is all about. Talk to us about it.
Well, firstly, the Constitution is clear that it sanctions continued application of statutory law that pre-exists the Constitution, the common law and customary law, and in addition, the traditional court system and, of course, the traditional leadership, which essentially presides over that system, continues in existence. But all those legal systems continue to apply to the extent that they're consistent with the Constitution. We have, over the past over 2 decades, been battling to find the right kind of legislative framework that would supersede the apartheid erstwhile legislative framework governing this traditional courts, and there has been a lot of disputes around issues of gender, as you had said earlier, but many other issues associated with what some perceive as establishing a dual system of justice.
Yeah. So what, through my understanding, a couple of changes that have been made, and let's focus on the gender issue for a while, is that the changes include that traditional courts must be made up of men and women for these courts to promote and protect the representation of women. This is a very big issue and one that I know was of great concern in these courts.
Yeah. Well, already you'd noticed that the Constitutional Court has ruled in a number of cases where in favor of women rulers under a traditional system of governance. And you know that traditional leaders constitute the core of those judicial institutions, and therefore, by implication, women will preside over these courts, and therefore, already the Constitutional Court has set the principle of women participation at that level. But it goes beyond that in terms of participation as litigants in disputes. Women would have full rights of self-representation in those proceedings as well.
Yeah, I'm also reading that parties would be able to opt out of the traditional justice system, a provision that was not available in the draft of the bill. How is this going to work? And just explain that a little bit further, the opting out provision.
Well, you must understand that generally persons who still adhere to a traditional way of life very often also, in many instances, also follow the mainstream system in their everyday lives, and therefore it is in recognition of that dualism that it was felt that persons should have that kind of option. But of course, once you've, at the commencement of the proceedings, elected a preference, you are bound by it right through the end of the process.
Yeah. Again, another provision in this bill. I'm going to try and go through them as concisely as I can. There's also in the previous bill, it provided for fines to be imposed for the deprivation of customary law benefits. Now the bill provides for compensation as opposed to fines. Again, why was this decided upon?
Well, the thrust of the bill is to de-emphasize a criminal role of the court and focus on what generally you would call a civil kind of dispute resolution mechanism. Although that would not be an accurate descriptor, because there are minor disputes of a purely criminal nature, which would still be covered, recognizing that traditional law itself makes very little distinction between criminal and civil, and even for that matter, delictual and criminal, instances. Well, delictual being civil.
Yeah.
So the critical thing, hence, was to attach a schedule, which may not necessarily be exhaustive, but illustrative of the kind of matters, so as to create some degree of certainty as to what kind of matters can be brought before these courts.
Yeah. But one thing, however, that has stayed the same is that in a traditional court, you're still able to be there and not have legal representation. You can have a non-adversarial, and lawyers might prolong the process, is what they feel. So you could have a family member representing you.
And this is not unique.
Okay.
Under labor law, both in the CCMA and even in the labor court, you can have a shop steward represent you. So it's not unique in this dispensation. And of course, you can talk of small claims courts where lawyers are not involved. So, but what's critical, I think, is that this becomes an addition to our suite of alternative dispute resolution institutional arrangements as a way of diverting disputes away from the adversarial system of formal litigation.
All right. Minister, thank you for talking to us about this and coming to give some clarity. Obviously, it's now been made public and it's open again for discussion. But I'm going to put you on the spot a little bit because there's a story, that an expose that we've had here on the SABC, and I'm just going to ask the crew if they are listening, and if perhaps we can get a copy of that going, about a young schoolboy in Mpumalanga who has been paralyzed by his school principal for allegedly stealing 150 rand. He's only now been suspended. I don't know if the crew, have you got that story? Do you have the visuals, crew? Are you listening? They're going to try and bring it up, but it's a very devastating story, and the fact that the principal has only just been suspended now, and this kid is now in a wheelchair and is wearing nappies. I'm putting you on the spot because you're not aware of the story, but in an instance like this, what can the justice system be doing? Should this not be fast-tracked, that this principal should go to court? In fact, we've got the story, Minister. I would like to show it to you now, if you don't mind. Just have a look and have a listen.
Okay.
The principal allegedly tripped and pinned Siphamandla Chuma down with his knee on his chest. The 14-year-old subsequently lost feeling in his legs and has to use diapers.
The reason why it took so long for the department to act on the matter is that the matter was reported on the first week of December, when schools were getting ready to close. What was happening is that we still needed the principal to be back at school when schools reopened for further questioning.
The principal refused to comment.
What are you planning to do?
What must I do?
Are you going to defend yourself in court, or?
Only showing us this Bible scripture that reads, "You don't have to do anything. The Lord will fight for you." The family says police failed them.
The case was opened last year during December on the 6th, and of course, when it was opened, we then took relevant statements, and such statements have then been presented before the public prosecutor for a decision. And after such a decision has been taken, the prosecutor decided that there are further statements that we need to take, and we are busy complying with that instruction of the public prosecutor.
When the SABC visited the family on Monday, the boy was left alone with his 12-year-old sister and another infant. The Department of Social Development has already sent social workers to visit the family. Sibongile Mkanimbolweni, SABC News, Middelburg in Mpumalanga.
Minister, that's the story we've been talking about, and it's a devastating story. From a justice perspective, what's your reaction to something like this?
Well, I'm equally devastated because the law prohibiting corporal punishment at schools has long been passed in South Africa, and its constitutionality up to this point has never been challenged. And therefore, I cannot for my life believe that there are still schools which, here it's not even corporal punishment in the ordinary sense, it's outright violence against children, which is completely unacceptable. Teachers are said in law to be in loco parentis. In other words, they stand in the place of parents. Their role is to protect, not to abuse children. But in terms of the criminal justice system, I should be able to follow up with the National Director of Prosecution and obtain a report as to what actually is happening, so that there is a speedy justice that gets to be meted out in this instance.
Please do, Minister, and we appreciate that. Thank you very much for being with us and for responding to that on the spot here.
Yes.
A story that we are covering and trying to get to the bottom of, because this is absolutely unacceptable that it's happening in our schools. Michael Masutha, of course, is the Minister of Justice here in South Africa. Let's take a break.